On a cold December morning, the 9 Supreme Court justices gathered to hear a case that could reshape our government. The question: can the president fire leaders of independent agencies for any reason? The answer will impact everything from product safety to election fairness. These agencies make rules that touch our daily lives, protecting consumers, regulating markets, and ensuring workplace safety. Traditionally, they've operated with independence, shielded from political winds, so experts can focus on the public good. Now, the court must decide: should that separation continue, or should the president have direct control? The outcome will determine whether these agencies remain insulated expert bodies, or become extensions of presidential power. The ripple effects will be felt by every American for decades. To understand this case, you need to know what independent agencies are. Unlike cabinet departments, these agencies, like the Federal Trade Commission and Federal Reserve, were created by Congress to handle complex technical issues with political neutrality. Congress gave their leaders job protections. They can only be fired for cause, not for political disagreements. This structure was cemented in 1935 by the Supreme Court's decision, which limited the president's removal power. For nearly 90 years, this precedent has protected the independence of agencies that regulate critical sectors of American life. Bipartisan boards and staggered terms encourage stability and expertise, preventing abrupt policy swings with each new administration. This system ensures long-term thinking and consistent regulation. Now, that very structure is under threat in the current Supreme Court showdown. The legal battle that would grip the nation began in March 2025, setting off a chain of events that would soon reach the highest court in the land. It started when President Trump abruptly fired several Democratic members from independent federal agencies, most notably FTC Commissioner Rebecca Kelly Slaughter. These dismissals sent shockwaves through Washington, as they targeted officials who were supposed to be shielded from political interference. Unlike typical firings for misconduct or incompetence, these were based purely on policy disagreements. This move directly challenged a long-standing tradition that such officials could only be removed for cause, not for their political views or policy stances. Rebecca Slaughter decided to fight back. She filed a lawsuit, arguing that her removal violated the statutory protections established by Congress and reinforced by decades of Supreme Court precedent. Her case quickly became a rallying point for those concerned about the independence of federal agencies. As the case wound its way through the courts, lower judges were deeply divided. Some sided with the president's authority, while others defended the agency's independence. The Supreme Court's decision to take up the case signaled a possible re-examination of a foundational principle of American governance. In a dramatic move, the court allowed President Trump to remove Slaughter even while the case was still pending. This unprecedented step suggested that the justices might be ready to overturn decades of established precedent. The stage was set for a historic showdown. At stake was a fundamental question: is the president's authority over independent agencies truly absolute, or are there limits to executive power? The outcome of this case will determine not just the fate of one commissioner, but the future of dozens of federal agencies that touch nearly every aspect of American life, from consumer protection to financial regulation. This is far more than a legal technicality. It's a referendum on the very balance of power between the presidency and the independent institutions that help govern the country. The stakes could not be higher, as the nation awaits a decision that could reshape the structure of American democracy for generations to come. The Trump administration's lawyer made a sweeping argument. The Constitution, he claimed, gives the president full and undivided control over the executive branch. This means the president should have the power to direct, supervise, and, if necessary, remove anyone who works in the executive branch, without interference from Congress or the courts. According to this view, so-called independent agencies create what the lawyer called a headless fourth branch of government, an unelected bureaucracy that operates outside the president's authority and undermines democratic accountability. The lawyer argued that if the president cannot control agency leaders, then voters lose their ability to hold anyone responsible for government actions. In a democracy, accountability is supposed to flow from the people to their elected leader, and from the leader to the officials who carry out the law. The administration's lawyer pointed to a 1935 Supreme Court decision that upheld agency independence but called it outdated. He emphasized that today's federal agencies wield far more power and influence over Americans' daily lives than they did nearly a century ago, making the issue even more urgent. He insisted that agency heads must answer directly to the president, who is the only official elected by the entire nation to carry out the people's will and set the government's agenda. Without the power to remove agency leaders, the president's policies can be blocked or undermined by officials left over from previous administrations, leading to confusion, inaction, and political gridlock. Supporters of this argument say it's not about creating an imperial presidency or tyranny. It's about restoring the original constitutional design and making government more responsive and accountable to voters. Overturning the old precedent, they argue, would clarify that the president is ultimately responsible for the entire executive branch, as the framers intended. This would ensure that the lines of authority are clear and that the president can be held accountable for the actions of all executive agencies. In the end, it's a call to restore clear lines of authority and accountability so that voters know exactly who is responsible for the actions of their government. Rebecca Slaughter's lawyer defended agency independence, arguing that Congress has the authority to create expert bodies insulated from politics and day-to-day partisan pressures. For nearly a century, bipartisan consensus has held that some government functions require impartial experts, not political appointees, to ensure fair and balanced decision-making. Agencies like the Federal Reserve and Consumer Product Safety Commission make decisions based on data, research, and expertise, not partisan loyalty or shifting political winds. If presidents could fire agency heads for political reasons, public trust and institutional integrity would quickly collapse, undermining the agency's core missions. Overturning these protections would destabilize government, threaten job security for agency leaders, and create widespread economic uncertainty for businesses and families. Independence preserves expertise and continuity, ensuring agencies can protect the public interest and maintain stability even as administrations change. The lawyer warned, politicizing these agencies would make government less effective, less stable, and less capable of serving the needs of everyday Americans. The justices' questions during oral arguments revealed a sharply divided court, with each side probing the limits of presidential authority and the role of Congress in shaping the executive branch. The conservative majority seemed sympathetic to expanding presidential power, with Chief Justice Roberts notably calling the old precedent a dried husk. His comments suggested a willingness to reconsider long-standing legal boundaries, and he pressed attorneys on whether the current system unduly restricts the president's ability to manage the executive branch. Justices Kavanaugh, Gorsuch, and Alito questioned whether Congress can limit the president's control over executive officials, raising concerns about separation of powers and the potential for legislative overreach into executive functions. Justice Thomas, who has long advocated for a strong executive, appeared ready to rule for more presidential authority, signaling that he sees the current restrictions as inconsistent with the Constitution's original design. The liberal justices, led by Justice Kagan, warned that giving the president unchecked power could dismantle consumer, environmental, and financial protections overnight. They argued that independent agencies play a crucial role in safeguarding the public interest, and that weakening them could have far-reaching consequences for ordinary Americans. Justice Sotomayor defended the importance of precedent, warning that overturning it could destabilize the entire government structure. She emphasized that stability and predictability in the law are essential for both government agencies and the people they serve. Some conservatives hinted at protecting the Federal Reserve's independence, even if other agencies lose their protections, suggesting that certain institutions may be seen as too vital to risk political interference. The court's final decision may hinge on whether any exceptions are carved out for key agencies, or if a sweeping change will apply across the board, fundamentally altering the structure of federal oversight. Whatever the outcome, the decision will reshape the balance of power in Washington, with lasting effects on how the federal government operates and how future presidents wield their authority. The Supreme Court's decision, expected in June 2026, will have sweeping consequences. If the president wins, agency leaders will lose their independence and serve at the president's pleasure. Regulations could change overnight. Imagine a president firing the Consumer Product Safety Commission to block a recall, or dismissing the Federal Election Commission to halt an investigation. The stability and predictability of federal regulation would give way to uncertainty and political swings. If the court upholds agency independence, it preserves a system where experts make decisions insulated from partisan politics. This would maintain regulatory stability, but frustrate presidents who feel blocked by unelected officials. Ultimately, the case is about the character of our government-concentrated executive power, or distributed, expert-driven stability. The Supreme Court's answer will shape American life for generations.